terrific. And Mary Hart, it's really a true pleasure to be here with you again.
Thank you. Thank you. Thanks for having me. Just to follow up on the wig story, it was funny because Jim and I had been on teleconferences together, so we knew each other through cyberspace or whatever, but we'd never met. So I sit down at the dinner and I have this wig on and we have a whole dinner conversation. It's great. The next day I run into him on the boat and he thinks I'm a stranger. He has no idea who I am just because I took the wig off. And I had, this short curly hair. So anyway, it was kind of funny. I start talking and I think he recognized my voice and he's like, Mary? And I'm like, yeah, like it was only last night. He's like, I thought that was your real hair. Anyway, so that was very funny. Just a little bit about my background so you know why I'm theoretically qualified to stand up here and teach to you guys about what I'm going to teach to you about. I have been an attorney for 28 years. I've been a 1031 qualified intermediary since about 2004, so 15 years. I've been an investor for about 15 years. I invest currently in a commercial property, do a lot of private lending. I've had vacation rental properties. I have a retail property. I now have this big farm that may become a wedding venue or an equine boarding facility, or right now it's a fledgling beef cattle operation. But anyway, so I've got a lot of different experience, and I'm trying to retire from the law and just consult because I don't want the restrictions of the law license. And by that I mean I can only represent people in North Carolina as a lawyer. And as I've taught around the country for the last 10 years, I've had a lot of people who want me to help them, and I can't really do it very well as a lawyer because my professional license says I can't. But I realized after a lot of people talk to me that I have still all the same experience, the same knowledge, all that I can consult with real estate investors. You just can't sue me for legal advice. You just have to take it for what it is. But anyway, so that's what I'm doing now is I'm consulting, and I'm going to start a coaching program for young people in the financial literacy world, the life cycle of wealth, wealth and wellness, so all sorts of areas of life. I have 3 boys between the ages of 19 and 26, and so when I realized they don't want to listen to their mom, maybe I can teach some other people what I'd really like to teach them. But in fact, my middle son has been driving Uber, and I've been trying to talk to my kids about real estate investing forever, and they won't listen. And finally, my son calls me up, and he had some guy in the back of his Uber who's a real estate investor. He's like, oh my gosh, Mom, I got to do real estate investing. I'm like, really? You have a 30-second ride with an Uber passenger, and now you want to talk about it? Anyway, so they don't listen to their parents. So I finally decided somebody needs to teach these college students financial issues and literacy. It's a language none of us learn to speak unless you come to conferences like this. So that's what I'm going to do on the really cheap, and I'm hoping the consulting business will help me allow these young people to have it for $25 a month, because you got to pay for something to value it, but I'm trying to do it cheap for them. So anyway, so the topic today, it's interesting that Jim says multi-generational cash flow, because what I find with my real estate investor clients and friends and myself is that we're so busy trying to make the money, prepare for our financial freedom, and hopefully leave something to our kids if we have them one day, that we don't really pay attention to what we need to do to protect what we're building, right? So in my mind, you've got the whole life cycle of wealth, how you make it, right? First you start out maybe as an employee or business owner, and you're working your way towards investor. But people fail to pay attention to how do you protect it, whether it's from taxes or creditors, how do you make sure the deal goes well, all these things that people don't want to look at the details and the boring part of it. You want to do the fancy, sexy stuff, and I get to stand up here and talk about the scary, boring stuff. But if you're going to work so hard to build something, we need to make sure that you can keep it, right? Because it's not really what you make, it's what you keep. And so I just put together, I started out doing the top 10 mistakes, and then I realized I was quickly up to about 50. And then I decided that, I only had an hour, so I was like, wow, this is going to go really fast. And I do talk fast, obviously, right? Lightning lips, right? Okay. Yeah. I've been called that before by a judge. That was not fun. But anyway, on the record. Anyway, I decided instead of going at it from, don't do this, don't do this, don't do this, and just talk about mistakes, I wanted to switch the tone of it to best practices for avoiding mistakes. So there'll be some of the don't do this, but really it's more what I want you to pay attention to and focus on. And so it is not a fun topic, but I think it's a very, very important topic because you guys are working hard to build your wealth, to build your legacy, your financial freedom. Let's take time to learn that you don't know what you don't know and pay attention to some of the boring details. So I apologize in advance for the boringness of it. But I say you don't know what you don't know for a reason. Even I, as a 28-year lawyer, don't know what I don't know, right? I mean, until something comes up, you're like, well, I didn't know that. You didn't know you didn't know that, right? And so the more you can come to conferences like this and learn all the different things, you can learn what you don't know. But just be aware and have your mind open when you're around people. And don't listen to the wrong people. There's a lot of cocktail party fodder. So if someone's telling you something, make sure they know what they're talking about. Ask them their experience. How do they know that? Where did they learn that information? I'll give you an example. Just this morning, scrolling through Facebook, and there was some group, I can't remember which group it was, and somebody's asking a question about LLCs for their rental properties. And all these people chimed in, and 99% of the answers were flat out wrong. Flat out wrong. Like, oh my gosh, please don't do what these people say. And I was like poised over the keyboard. Oh boy, I just need to chime in here. I thought, no, I'm out. Because one, I didn't want to get in an argument with a bunch of people on Facebook. Two, I was trying to get dressed to come here this morning. I'm like, no, I don't have time to do that, and everybody's going to be arguing with me. But it was just wrong. So don't get your legal advice off Facebook unless you know that it's like John Heyer or somebody who's answering you and they know what they're talking about. Because I see a lot of wrong information. Speaking of John Heyer, I think the other reason that I see that real estate investors make mistakes is what John Heyer says. You're like little chicks. Cheap, 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 cheap. Right? That's a John Heyer thing, but I always laugh when he says it and he's much funnier than I am. But how many of you guys know John Heyer and have heard him speak? So you know what I'm talking about. But this brings me to, in the law, and most of my mistakes are legally related. They're not all about the law, but what I have found is that there are two ways to use the law. You can use the sword of the law, where you wait until there's a problem, then you come out wielding your sword and try to fight that battle. Am I not on?
You just keep talking.
Oh, sorry. So you can use the sword of the law and try to fight that battle, and that's being reactive, right, to a problem. Or you can use the shield of the law, that's being proactive, and you try to prevent the problem from happening in the first place. It is always, and I mean always without a doubt, cheaper, less stressful, less of a headache, and less time consuming to just learn it and do it right the first time. Always use the shield of the law and be proactive as much as possible. Now sometimes we do everything we think we're doing right and a problem may still occur and you have to pull out the sword and fight that battle. But what I'm trying to do today is give you some tips to help you be proactive so that you have less money for lawyers, less time and headache, okay? And I'm trying to use readers, so I've got like these giant words on my screen. I didn't do a PowerPoint because one, I just would be bullet pointing what I'm going to say, and then I get lost in the PowerPoint and I don't really tell you the things I want to tell you. So I'm just picking random topics. But because I started out my career as an estate planning lawyer and we're talking about multi-generational cash flow, I want to start first with what I call life and death planning. Some people just call it estate planning. I think it's bigger than that. When people hear estate planning, they think just about when you die. But there's a lot of planning that needs to go into what happens during your lifetime. What if you become disabled during your lifetime for 1 minute or the rest of your life? A lot of people don't even say, I don't need to do an estate plan. I'm 30. I'm going to wait till I'm 70 and then I'll do it. Well, we don't know how many tomorrows we're going to have, right? I don't care whether you're 21, 81. We don't know. And you don't know whether or not you're going to be perfect and just drop dead on your 99th birthday and everything's already in place and you don't need to worry about it. So I want people from the age of 18, everybody should have at least a bare minimum slew of documents. And when my kids turned 18, that's what they got for their birthday, by the way. They got an estate plan for their birthday. They did not think it was sexy or fun. But on their 18th birthday, they had to come to my office and sign their will and all their powers of attorney. I gave them some cash and good dinner too, but anyway. So the first thing that I think everybody needs to have is a disability plan. You know, we don't know whether we're always going to be able to make our own decisions, right? So particularly if you're out there in the real estate investing world, you've got loans out, you've got properties, you're in the middle of closings, you're doing this and that. What happens if somebody runs through the stop sign and hits you and you're in a coma for 6 months? Do you know that there's somebody out there that can make your decisions? Or does everything stop and you lose the closings and the loans get called and nobody can operate for you? What happens? You're screwed, right? So a lot of people say, well, my spouse can do that for me. Not necessarily. Not necessarily. You know, if I own a piece of property, just because I own it doesn't mean my spouse can go do the closing. I have to sign that deed too, right? So if I don't have the right documents in place and I become disabled and I'm in the middle of a million things, or even if one decision needs to be made for me, my health insurance needs to be renewed and I can't sign it, the littlest decisions, then if I have not put powers of attorney in place, someone's got to go to court and get appointed as my guardian. That's probably minimum 6 months and $5,000, minimum. What are you going to lose in that 6 months because somebody couldn't sign for you or act for you? So it takes like $100, $200, put a power of attorney in place to say, if I'm not able to act myself, so-and-so is my agent. And list all the areas and be as broad as possible in which that person can act. Because that way, if something happens to you, they just step right in. Hey, I'm pretending to be Mary today. You know, say it's my spouse, Frank Hart, as power of attorney for Mary Hart, or whatever it is, or my brother, who I can't even remember who I've named right now. It's terrible. I know my spouse is my healthcare power of attorney, but he doesn't like dealing with money and investments. So I think I made my brother my financial power of attorney. Anyway, name an agent, a power of attorney. Name a successor. Name a second successor. In my perfect world, everybody would name at least 3 people. Because what if the person you named, let's say it's my spouse for me, and we're in the car wreck together? And we're both disabled, right? Somebody needs to step in. So I try to name 3 layers on everything. Very, very important. The other part that I think is critically important, and I like to tell war stories. I'm going to tell a little war story in a minute about this, but I think it's critically important to make sure your power of attorney has language in it that makes it effective even if you become disabled. Back in a long time ago, we did not have what's called a durable power of attorney. And that power of attorney, you know, if I gave Lisa Englehart my power of attorney and I became disabled, by law that power of attorney was revoked. Well, that's kind of stupid. That's usually when you need it, right? So the legislatures came in, I don't know how many years ago now, and created something called a durable power of attorney. It endures a subsequent disability. It stays in effect. But in order for it to be durable, you have to have language in it that makes it durable. So it'll say something like, this power of attorney shall remain in effect in the event of my subsequent disability or incapacity. If it does not have that language, it will be revoked the moment you become disabled by law. So the war story is, when I was a baby lawyer 28 years ago, I was practicing in Juneau, Alaska, and I had a new client coming in from Ketchikan. So this was a woman who flew in from Ketchikan. I think she was about 70 years old. She was married to an older man who was in the Alzheimer's wing of their local hospital in Ketchikan. They were real estate investors. They were asset rich and cash poor. And this guy was in the Alzheimer's wing, and he had $12,000 a month bills for the Alzheimer's wing. And this woman said, I need to sell this apartment building to raise cash to support her husband. So she scheduled an appointment with me just for me to prepare a deed for her. She had a buyer lined up to buy this, and we were doing a little closing type thing. And she came in and she told me the situation. I realized her husband was incompetent, and I said, do you have his power of attorney? Oh, yep, we did it years ago. Here you go. They went to a stationery store and bought this piece of paper. It was the old version of LegalZoom, all right? You go in the stationery store, you grab the document that says power of attorney, you think you're good. So I read this power of attorney and realized it was not durable, meaning the moment he became incapacitated, that whole power of attorney was revoked. She had no power to act for him. So what that meant was we had to go get her appointed as his legal guardian. We had to notify all his adult children, one of whom was an estranged child that they had not seen in 40 years. They had raised that child's son. It was my client's stepson. And that child had fled 40 years early. They didn't even know where she was. So long story short with this, instead of walking out with a deed 30 minutes later, we spent almost a year trying to go through this guardianship. She spent probably $10,000. We had to go find this one. It was a mess. And not only that, but the worst part was she lost her buyer. She was petrified that this girl, this woman, was going to show back up and cause problems. Petrified. Lost sleep over it for a year. It all worked out in the end. She found a new buyer, but that could have been avoided if that power of attorney had one sentence in it that she didn't know needed to be in there. She didn't know what she didn't know, right? So that's a big mistake I see people make is, one, not having the right documents, two, not making sure it serves the purpose correctly. So that's a durable power of attorney. I think everybody, once they're 18, should have the durable power of attorney. You should have a healthcare power of attorney. HCPOA is how I abbreviate it. Who makes your healthcare decisions if you can't make them yourself? Name 2 successors. Very important. A living will is a very personal decision. That is what I crudely call the pull the plug document, right? If you're in a coma and you're being kept alive on artificial life support, do you want to be kept alive forever on artificial life support, or do you want them to pull the plug and let you die naturally, right? If you do not have a living will that says, I do not want to be kept alive artificially, you are probably at risk for being kept on that artificial life support potentially for years and years and years and years, and every bit of your wealth will go to the hospital while you're lying there in a bed not even having a clue who you are, much less your family. And so everything you've worked hard for could go down the tubes, and millions of dollars, and I've seen it happen, of hospital bills because you didn't authorize the plug to be pulled. It's a simple document. Just says, if I'm in this situation, terminate life support. Okay? It's a personal decision whether you want to have that document. But if you don't want to be kept alive, please do a living will. It's also called in North Carolina a declaration of a desire for a natural death. That's too long to say. And let me just clarify too, that's not the same thing as a do not resuscitate order. There's a lot of confusion about this. People think, well, I'll just get a do not resuscitate order. That's a very different thing. A living will, if you drop in your apartment or your house, you have a heart attack, the paramedics will take you to the hospital and try to, the doctors will try to revive you. The living will just say, if you can't revive them, don't leave me alive on artificial life support, right? A do not resuscitate order is something you get with your doctor if you already have a terminal illness. And it basically instructs the paramedics, don't even revive me because I'm going to die of a terminal illness in a couple weeks anyway. You know what I mean? Don't go through all that trauma if I'm already dying. That's not a living will. So very, very different things. All right, so first, have a plan, have a disability plan. Something people don't realize is if you're doing a trust for planning purposes, a revocable living trust, for instance, that also is part of your disability plan, because if you've got your assets in this trust, and we can talk about that later, and you're the trustee, if you become disabled, your successor trustee just steps in and can start managing everything right then and there. Right? So remember that a trust can be part of a disability plan as well. And we'll talk more about the trust in a little bit. And by the way, we have a lot to cover, but I'm fine if you have questions. I don't know, Jim, if you want to wait for the panel or. Okay, so write your questions down so we can get through all this, but feel free to ask questions or catch me on a break. I'll be here till tomorrow at about lunchtime, then I have to fly to another conference. Okay. And just keep in mind, people don't put a plan in place for many reasons. One of them is we think we have plenty of time, and you don't know whether you're going to have plenty of time. Second is we don't have a crystal ball, so people don't know what to do. And that's part of what a good lawyer, or what I do in my consulting business now, is help you dig down in those issues and identify what you need to be thinking about. So don't not do it just because you don't know where to start, or you don't know how to make a decision. Let somebody talk you through the pros and cons of everything. All right, so death planning. Just make a plan. It could be as simple as a handwritten will at your kitchen table. If you do a handwritten will, by the way, it needs to be in your handwriting to be effective. You can't type something on your computer and just sign it without the formalities of the law of witnesses and a notary and all that kind of stuff. So if you want it to be effective, it has to be in your handwriting. Otherwise, you've got to do notaries and witnesses anyway, okay? But you can write it. Frankly, if you're going down in an airplane, you can write a will on a cocktail napkin, and if it survives the airplane crash, it is a valid will. Just say, it's my will, write what you want, sign it, date it, it's a valid will, okay? That works, but I don't suggest that, and especially not the plane crash part. But let me also make a comment here about the LegalZoom type of will. I have a lot of people that ask me, well, can I just do a LegalZoom will? First of all, I'm going to say no, because you need to hire me. But and I actually am not drafting documents anymore, so you can't hire me to do that. But in my experience, what I have found with those types of programs is because people don't know what they don't know, and LegalZoom doesn't ask enough questions or dig down deep enough, then those wills are usually either vague or incomplete. And every single will contest I've ever been involved in has involved either a handwritten will or a digital LegalZoom type will. Every single one. Because they're vague. Or they don't take it down to the next level. They say, you know, I leave everything to Steve, and then I stop. Well, what if Steve died before me or with me? And I don't have anything where it goes next, right? So just be careful. They're better than nothing, but I would prefer that you go hire your lawyer to do it, because they're, if you get a good one, theoretically going to ask you the right questions and go down enough layers to make a really effective document for your goals. I can help with those in terms of discussions. If people, you know, just want to come up with a ready plan and take it to their lawyer, that's where I'm coming in. But I don't want to draft documents anymore, frankly, because I've done it for so long, it's a little boring. But second, it costs me like $8,000 a year in software costs that I don't want to deal with anymore. I just want to help people come to the decisions, write a memo, and they can take it to their lawyer. So I'm at that age where I get to be a little bit lazy about that. Okay, so here's the next critical thing. So number one at death planning, have a plan, do something. Number two, and this is part of the plan, make sure you learn how assets pass at death. And the reason I say that is because one of the literally biggest mistakes I see when people don't understand how assets pass at death, the mechanism by which things are titled different ways, they're held different ways, and the way things are titled will dictate how they pass at death. Am I getting feedback or something?
She is.
Okay.
Continue on.
And people don't understand how things pass at death, so their plans don't get effectuated properly in many cases. And I'm going to give you an example.
Okay.
For instance, if you own something in your separate name, so your name's on the deed, no joint owner, not in a trust, that piece of property is going to go through your will. Any asset you own in your separate name will go through your will if you have one, or through the laws of intestacy if you don't have one, which is the state-created will. Your state is going to make a will for you if you don't make one for yourself. So and we call those your probate assets. So the only thing that goes through that are things in your own separate name. However, let's say that Jim and I own a piece of property as a joint tenant with a right of survivorship. If I die, at my last breath, he owns that property automatically. It's not going to go through my will. So even if I say I'm leaving it to you in my will, it's not going to go through my will. I didn't own it in my separate name. So I have this great fancy will I've paid a lot of money for. I think you're going to get the property. Nope, because I didn't understand how it passed at death. Same thing, a retirement plan, a life insurance plan, a pay on death account, things that have a written beneficiary. It's going to be governed by your beneficiary designation, not your will. Okay, so I'll give you a quick horror story about that, a war story. Again, when I was a young lawyer, I ended up representing two young men whose mother, they were like 21 and 23, whose mother in her early 40s had died in a tragic scuba diving accident. The mom was in a same-sex partnership and had been for many, many years after, I guess, she divorced their dad. Anyway, early on in that partnership, she was a state worker for the state of Alaska, so they have huge retirement plan benefits. And she had written her beneficiary form that left, I'm trying to remember what it was, 75% to the kids, 25% to her partner, right? Back earlier on in their relationship. Sometime later, she wrote a will, and she changed that percentage, 50% to the partner, 50% to the kids, right? And then she died. What do you think happened? 75-25. The will didn't govern it. It had a beneficiary designation. It had nothing to do with the will. That was completely irrelevant. I guarantee you that woman was turning over in her grave because she thought her partner was going to get 50% of it. So the partner tries to go get 50%. We're like, you're not entitled to 50%. So they end up in a big fight. The boys hired me, and we ended up negotiating, and she got less than 50, but more than 25, somewhere along the middle. But I guarantee you that woman's intents were not effectuated because she did not understand how assets pass at death, right? So if it's in your separate name, it goes through your will. If you have a joint tenancy with a right of survivorship, it goes to your survivor. If you have a tenant in common, you guys have some deeds maybe that say tenants in common, that's treated as your part as in your separate separate names. So Joyce, if you and I have a piece of property 50-50 as tenants in common, if I die, my 50% goes through my will, your 50% goes through your will. But we take that same piece of property and now our deed reads joint tenants with the right of survivorship, and I die, you own 100%. See the difference? People don't pay attention. What's your default law in your state when you've got two people on a deed? It's probably different if you're married to each other versus not. But you need to know what the default law is in your state. Is it considered with the right of survivorship by default if you don't actually define it in the deed? Or is it tenants in common? That will completely change who ends up with the property. Right? Does that make sense to everybody? Pay on death, like take your retirement plan beneficiary. Let's see, Joyce loves me. Gary. Joyce names me as 100% beneficiary of her retirement plan. Sadly, I die before her, and she has named nobody after me. What happens to that retirement plan? Does anybody know? It's going to depend on what the IRA documents say, right? That's first. You have to go back now to the IRA plan document or the retirement plan document and look at it. Probably it would go to Gary, your spouse. But we don't know that. What if it kicks into your will? Well, now we've probably just created huge income tax problems for the beneficiaries if it's a traditional IRA, because we probably have to pay it all out at once and the beneficiaries have to pay a bunch of income taxes. But because somebody didn't name a successor beneficiary, we've screwed up whoever does get it. You see what I mean? So you just have to pay attention to how things pass at death and make sure that you have things, the right documents set up. Is it joint with survivorship? Do you want your survivor to get it, or did you want your spouse to get it? You know, Joyce, if you and I were in a partnership on a piece of property, you might want your half to go to Gary. But if it said joint with the right of survivorship, guess what? The survivor takes it all. Whoever takes the last breath is the winner, right? And then I pass it to my heirs. So Gary and Frank will have to duke it out, but anyway. Frank would win because the paperwork. Yeah, Frank's a big guy, but the paperwork would win in that situation. Even if he were scrawny, the paperwork would win. Okay, let's see where I was in this. So, does this make sense to everybody? Okay. Another issue, let me tell one more war story, and I know I can't tell too many or we'll run out of time, but this one is a very, very important one. So there was a woman, real estate investor in Asheville. She lets me tell this story. In fact, I have it on video somewhere, but her name is Marcia Long. And Marcia was second marriage to a man, and I'm sorry, I've forgotten his first name because I never knew him. But anyway, they were very, very successful real estate investors, and they were doing all kinds of deals. They had a huge rental portfolio. They were developing properties. They had all this going on. They were in their 50s. And Marcia had 2 children from a prior marriage, and she and her husband had been, Steve was his name. They'd been together for many, many, many years and built this whole business up. But everything was in his name. Everything was in an LLC that was in his name. They never put her name on the membership. Well, Marcia gets a call one day that Steve's been in an accident, and that's all she heard. You need to come to the hospital, your husband's been in an accident. She goes to the hospital, turns out he was dead. He had an aneurysm driving down the highway. Luckily, he didn't kill anybody else. He died instantly. His truck ran off the road. Everything he owned was in that checkbooks, all the stuff to manage the business, everything. Well, I'm going to cut this really short, but basically, because he never did a will, they both assumed that everything would go to the survivor because, they were married. They'd been married for 20 years. Why wouldn't we built this business together? Why wouldn't it go to her? It didn't, right? Everything was in his name. He did not have a will. So that means it goes through the state-created will, the legislative will, intestacy. And what that said was that his parents owned half. She got half, his parents got half, her kids that he had raised with her got nothing, right? So the parents were unsophisticated, uneducated, did not know anything about the business. I think they got along with Marcia, but it wasn't a close relationship. They didn't live in the same town or anything else. And Marcia all of a sudden found herself trying to run this real estate business with no authority to do so. She says, I couldn't sell a painting off the wall. I couldn't close on any of the properties. The banks called all the loans because the LLC was in Steve's name. So all these massive loans they had out to do these developments and these spec homes, all called. She said, I was facing foreclosure, bankruptcy, everything, all because he didn't even have a simple will that said I leave everything to my spouse. It would have been, one paragraph would have done it. That's it. On a cocktail napkin, could have done it. Years and years and years went by. She ended up, I think, 3 lawyers fighting the parents, yada, yada, yada. Those parents, I think she had to give them, I want to say like $400,000 of the money that she and Steve had worked hard to build up. All because he didn't do one very, very simple document. So, you know, this is important stuff. It's boring, but it's important. All right, so another mistake I see a lot are people who want to give away assets to their kids during lifetime, whatever it is. Let me give a couple of examples. Somebody says, oh, I want to make sure that Medicaid pays for my nursing home. And this might not be you guys because you're successful real estate investors, but maybe you have a parent who says, I want to qualify for Medicaid, so I'm just going to transfer everything into your name now. That may or may not be a good idea. Part of what happens when you gift assets during life is you're gifting your income tax basis in that property. So if you've bought a property for $100,000 and now it's worth $500,000 and you give it away during life, you're giving your beneficiary that $100,000 basis. So now they go to sell it for $500,000, they've got $400,000 worth of capital gains. As opposed to if you left it to them at death, the basis in that property would jump up to the date of death value, say $500,000. They'd get it, a $500,000 asset with a $500,000 basis. They could sell it the next day, zero capital gains taxes. So people never, ever, ever take income tax basis into consideration when they're setting up trusts, gifting assets into irrevocable trusts, giving it to the kids, you know, all that kind of thing. So that's one mistake I see a lot. Another mistake I see is it's usually parents who, let's say in my case, I have 3 kids, and one of my kids lives nearby, and I want him to be able to manage everything. If I don't want to pay my bills, I want him to do my checkbook, whatever. So I take him to the bank, and I make him a co-owner on all my accounts, and I know that he'll just spend it the way I want it, and when I die, my will says to all 3 kids. So they'll all 3 inherit, but Chad's going to take care of me because he's the better kid that way. What did I just do? I just made him a co-owner. What happens when I die? He inherits the entire bank account. My will doesn't govern. He's a joint owner. So maybe he does the right thing, and he says, well, I'll give 1/3 to each of my brothers. Well, how much was in that account? Maybe I just sold an apartment building. I've got $500,000 in that account waiting for the next investment, right? He can give $15,000 to each of his brothers without having to file a gift tax return and use up part of his tax credit that he has during his lifetime. Is he going to do that? Is he going to give each of those kids a couple $100,000? Probably not. If he does the right thing and does that, he's just used up part of his tax credit, which means he could build up his wealth, but he could leave less to his kids in the future because he used part of his tax credit to give his brothers their rightful share. So in that situation, instead of making Chad a co-owner, I should have just given him signing authority, which means he could write checks for me when I'm traveling around the world because I've made all this money as a real estate investor. He can pay my bills for me, but when I die, it goes through my will or it goes to all 3 kids on a pay-on-death beneficiary designation. Do you see the difference? Again, I see that all the time. People don't think. They just do something for convenience and they don't understand because we're never taught this stuff, right? What happens at death? So you've got to understand how things pass at death. Another mistake I see in that arena, people do a great job. They go to their attorney, they set up their revocable living trust to avoid probate, and one of 2 things tends to happen. Either they have this beautiful trust and they think, I'm all set, the trust says what to do, I'm going to avoid probate, this is great, but they never put their assets in the trust. Right? So the trust only works if it governs something. It's only going to govern something if you actually put your assets in the trust. Now, if they've done it 3/4 of the way right, there should be a second document that's called a pour-over will that says anything that's not in my trust when I die, that goes through my will, pour it over into my trust so that it gets to the people that I've named as the beneficiaries in my trust. So if you have a revocable living trust, by the way, and you've done that, please make sure you have a pour-over will to be the safety net and pour everything into your trust because your trust says who gets it and how and where and probably has any tax planning provisions in it and all that. But so ultimately we might get everything through the trust, but now we've got to go through probate because nobody put their assets in the trust when they set it up. And that sort of defeats 90% of the purpose of why people set these up. So, okay. So remember I said a little earlier that what goes through probate assets, what goes through your will are things held in your separate name. I don't know, who asked the question? Okay.
What I meant was,
yeah.
you will explain that they need to redeed
Yeah, okay, let me take a quick sip of water.
That's what I'm saying. People don't understand
Yeah.
what you're saying.
Okay, good point. So let's say that you've gone to the lawyer and you've had this beautiful revocable living trust set up with the idea that it will avoid probate, meaning when you die, everything will just go to your beneficiaries according to the terms of the trust. Because the trust only governs what the trust owns, you have to make sure that trust owns your assets. So how do you do that? You have to transfer the assets into the trust, and we do that by whatever type of titling document you would do if you were just going to transfer it to a third party. Let's say I want to give everything to Steve. Pretend Steve is my trust. If it's real property, I'm going to deed it. So my deed will read, instead of Mary Hart to Steve Martin, it would read Mary Hart to Steve Martin as trustee of the Mary Hart Trust, right? Or to myself. That's what I have done, actually. Mary Hart is trustee of the Mary Hart Trust. So I'll deed my real property from myself as an individual to myself as the trustee of my trust. If it's a car, I go to DMV and I retitle it in the name of my trust. If it's a bank account, I go to the bank and I say, I can't have this account in my individual name anymore. It needs to be in the name of my trust. So whatever your titling document is, your stock account, tell your broker it needs to be in the name of the trust. And they'll paperwork you fill out. But whatever type of titling document you have for that type of asset, you've got to take it out of your name and title it in the name of yourself as the trustee of your trust. So a big mistake I see a lot with that is people set up all these LLCs as real estate investors. I'm one of them, right? Who's the member of your LLC? If you're individually the member, it's going to go through your will. It's not in your trust. So what do you have to do? You have to name your trust as the member or yourself as the trustee as the member. So I set up all my LLCs before I had my revocable living trust. So all my LLCs listed Mary Hart as the member. Once I set up my revocable living trust, then I had to do an assignment, and I just said, I, Mary Hart, assign all of my right, title, and interest into my such and such LLC to Mary Hart as trustee of the Mary Hart Trust. You see what I mean? I just assigned my membership interests from myself to my trust. Boom, now it's in the box called my trust. So I die, and people are trying to figure out, do I have to go through probate? Hopefully not, because nothing's in my individual name. It's all in the name of myself as my trustee, which puts it in the box of my trust. So if my car's titled in my trust, my LLCs are owned by my trust, my houses are owned by my trust, whatever it is, it'll just pass according to the terms of the trust because the trust owns it. It's governed by the terms of that trust.
Does that tie up your property in any way in trying to sell it or move it?
No. Does it tie up your property in any way trying to sell it or move it? No, and that's a good question. So these revocable living trusts are revocable. You're in charge, assuming you're your own trustee. You can put assets in, take assets out. It's ignored for tax purposes. It just goes under your Social Security number. And the only difference is what capacity are you signing the documents? In what capacity are you signing the documents? So instead of signing, just Mary Hart when I sign a deed, I'm signing Mary Hart trustee. And the seller was not Mary Hart. It's Mary Hart as trustee of the MEH Revocable Trust, or whatever I've called my trust. So it's just how you sign your name. Does that make sense?
Yeah. Does that make, so you didn't have to transfer any of the deeds over, that just, because you put the assignment on it, it all?
No.
No?
The assignment was for an LLC interest. So, you're talking about property that's owned by the LLC?
Correct.
Yeah. So if you've got a house that's owned by the LLC, all I did was change the ownership of the LLC to the trust. So the deed doesn't change. The deed is still in the name of the LLC. I just changed who owned the LLC, right? Yeah. So it's the same thing like if you're putting property in a land trust. If I've got property A in a land trust, I can change the beneficiary all day long in a land trust. I don't have to redeed that property, right?
Now, how would that work for bank loans?
How does it work for bank loans? Good question. So it depends in part on the type of property. Normally, when you get a bank loan on a piece of property, it says you can't transfer it or encumber it or do anything without the bank's permission, or they could call the loan due, right? There are some exceptions under something called the Garn-St. Germain Act. Like if you're transferring your personal residence to a revocable living trust, for instance, not a problem, right? If you're transferring just the member of your LLC, shouldn't be a problem if it's still you. Most banks don't care about that. Oh, only 10 minutes. Wow, we got a lot to go through. So it shouldn't be a problem. If you're transferring, if the property is in an LLC and you transfer the property to somebody else, then you got a problem because the loan's on the property. Do you lose the anonymity of the LLC? Depends on what you've named your trust. For instance, my trust is just called the MEH Revocable Trust. Don't anybody go find it and sue me. That's my initials. Meh. How is that? No, so what I do is I just say to the trustee of the MEH Revocable Trust, I don't put my name on it. Some states may require you to put your name on it, in which case you can do another layer, like a personal property trust or a land trust, or you can do some things to get around that. Let me go through here because we. Yeah, we got. I mean, we're only like mistake 2 people, and I got like 50 of these things. Yeah, so there are lots of things you need to do when you do a plan. I'm not gonna go through all the answers right now, but pay attention to if you have minor children, make sure you name guardians. If you have special needs beneficiaries, different things need to be done. If you have a second, third, fourth, or fifth marriage, things need to be done. I am a second marriage person. I have kids from a prior marriage. My husband has kids from a prior marriage. We have to be very intentional about our estate planning. Let's see, if you're drafting your own will, make sure you have what we call a residuary clause in it. So most people come in and they say, well, here are the assets that I own, and I want to leave this to Steve, and this to Lisa, and this to Joyce, and this to so-and-so. Well, they don't realize assets change over the years, right? So you always have to have one catch-all clause that says, and anything else I haven't mentioned goes to so-and-so. Right? Because otherwise we end up essentially without a will for some asset that you haven't listed. All right, I'm going to go through some retirement planning. I'm sure Quincy will talk about this more, but if you're doing a Roth IRA, even if you can only put $50 in it, set it up as soon as possible to get a 5-year clock running. And I'm not going to go into the details, but just we need to start a 5-year clock, and Quincy can go into more of that probably. Make sure you're designating proper beneficiaries on your retirement account. This really affects traditional type of retirement accounts better, the ones that you put in pre-tax dollars, because when those monies come out, they're subject to income taxes. And how we name our beneficiaries can dictate how rapidly those beneficiaries have to take the money and be subject to the income taxes. So if you've got, a $500,000 traditional IRA and you don't designate beneficiaries properly, we might end up dumping that $500,000 in your beneficiary's name in 1 year. So they've got to add $500,000 to their taxable income, which will bump them up right into higher brackets for everything. So I'm not going to go through all the details because that's a whole seminar, but talk to your professional about making sure your beneficiaries are designated properly so they can stretch out the payments over their lifetime. So they just get little bits. They can always take more, that's up to them, but we don't want to require them to take more than little bits each year. Does that make sense? And again, that's a whole seminar. If you do need to leave your IRA benefits in a trust because you're leaving them to minor children or disabled people or whatever, there are certain rules that have to be followed for that. So just don't be too willy-nilly about that. Something I see people doing wrong all the time when they're trying to invest with their IRA is mistitling the assets. So let's say if I had my IRA Quest Trust Company. If I'm putting an asset in that, like buying a piece of property through my IRA, it would be titled Quest Trust Company Custodian for the benefit of Mary Hart IRA number blah, blah, blah. It wouldn't just be Mary Hart IRA. You've got to have correct titling. So talk to your custodians about that if you're investing. Please, please, please pay attention or learn what constitutes a prohibited transaction if you're investing with your IRA. Very, very important. The rules are very black and white, and you mess up and the IRS doesn't care how well-intentioned you were, and the penalties are severe. So you can have a prohibited transaction only if there's a disqualified party involved, and again, this is a whole nother seminar. But learn who is a disqualified party, like your ancestors, your children, your descendants, various other people. If you're doing a transaction and a disqualified party is involved, make sure you know the prohibited transaction rules, because the penalties can be up to 160% of the value of your entire IRA. If you do it wrong, you do a prohibited transaction and you get caught, the IRS deems that IRA completely distributed out to you as of January 1st on the year in which the prohibited transaction was done. So a quick example, if I had $100,000 in my IRA and I loaned it to my son fair market interest and everything. Black and white prohibited transaction. Can't do it, period, right? What would happen, let's say I'm in a 35% tax bracket, I would owe 35% income taxes. This is a traditional IRA. I would owe a 10% premature distribution penalty because I'm under 59 and a half. Not by much, but I am. My son would owe a 15% excise tax as being the disqualified party. And if I don't undo the whole thing within a certain period of time, there is a 100% penalty. That's if I did a 100,000 loan and my IRA was 500,000, it's for my whole IRA. It would have been 500,000 that those penalties and interest would have applied to. So people who want to get really creative and do stuff on the edge with IRAs and 401ks make me very nervous. Do your more vanilla things in here, you can still make a ton of money. Just the penalties are huge if you mess up in your retirement plan, so you don't want to blow it. The one good thing difference in a 401k, by the way, if you do a prohibited transaction, it only blows up the amount of that transaction, not your entire 401k. The IRA, it blows up the whole IRA. Okay, so if you think there's a problem, and by the way, seek professional help if you have questions. Don't rely on the well-meaning custodians because, I've had clients who went in and talked to the custodian and they said, oh yeah, you can do this. Turns out they couldn't. They came to me, unfortunately, after the fact. Had they been audited on that day, they would have owed over $400,000 in taxes and penalties. And when the statute of limitations doesn't run because you don't file an income tax return reporting that income. So you could get them forever. All right. When you're using an IRA with an entity or trust, an LLC or a trust, there are specific rules that have to be met. So talk to somebody about that. And again, we can ask more on Q&A. I just want to see if there are any big things here before I run out of time. There's so many. If you're in a partnership with somebody, a couple of things I want to say real quick. By that I mean an LLC or a true partnership. You don't always have to have a written agreement, but I would have a written agreement. Spell it all out. Make sure you guys are on the same page, number one. If you're doing something together and you want it to be a joint venture and not be a partnership where each person is liable for the other person's actions, have a writing that says specifically, we are not in a partnership together, we are just doing a joint venture. Because otherwise, if it's deemed a de facto partnership, Steve, you go out and do something horrible. What's your first name? Kevin. You do something horrible. Kevin could be found liable for it because he was deemed your de facto partner, just because you're doing a joint venture together. So clarify, always clarify what it is you're really doing. If you are in an LLC or some partnership together, do your very best not to be 50-50 owners. Cannot tell you how many times we've ended up in court and everything else because the 50-50 owners don't agree and nobody has a majority vote to even hire the lawyer. Honestly, it's terrible. It costs tens and hundreds of thousands of dollars sometimes to even just get rid of a partnership or make a change in anything because nobody has majority vote. Nobody. So if you can't agree that somebody gets the vote and somebody's just more passive, 49-51, then have the written paperwork that has a tie-breaking mechanism in it. Otherwise, you're going to end up in court potentially for years just trying to get the court to say who has the right to make a decision or even dissolve it. I mean, I've seen it over and over and over again. Make sure if you're in an entity and you're soliciting funds that you are following the securities laws because you could get popped, you could go to jail. If you're loaning money on somebody's personal residence, make sure you're following the banking laws, okay? And again, we're not going into detail, we don't have time. If you're doing any kind of deal, obviously do your due diligence. Don't be afraid to ask for references. I'm doing a deal with somebody in this room, I'm the lender, they're the borrower. I love this person as a person, but I'd never done a deal with them before. I'm not going to even look at anybody, but protect their privacy. But anyway, I felt really weird. I asked for references. This is somebody I've known for a while. I said, I need references. And the only reason I did that is because I tell everybody else they need to get references. I was like, oh, okay. So I did it. I emailed the references, and they were all glowing. And it was perfect, and I funded the deal. But, I've had things happen where, I've been in social situations with people, oh, they're great, and turns out they weren't great to me, but I didn't check references or anything. So, do your checks, make sure it's a good person. If you're going to use a land trust, please know what you're doing and realize that a land trust is not by itself a creditor protection vehicle. It's a smokescreen. It does not have creditor protection like an LLC does, okay? We can get more into that later, Q&A. And if you are doing a land trust, please don't name yourself individually as a beneficiary, because whatever creditor protection might be there, you just destroyed. So always name either an LLC or another layer of land trust or personal property trust or whatever as the first beneficiary. If you name yourself as an individual, let's say here's your land trust, you've got your rental houses in it, here's you personally. There is no brick wall like an LLC gives you for creditor protection if you set it up and manage it properly. That is not there with a land trust. So if you run the stop sign and get sued individually, and you're the individual beneficiary of your land trust, and that they win their lawsuit, that victim, whatever, wins their lawsuit, they can step into your shoes as the beneficiary and direct your land trust. Okay? Don't name yourself as an individual beneficiary of your land trust. So let's take it now, this land trust as an LLC beneficiary. You get sued for the car crash. What does that creditor get in most states? They might get a judgment against you, but vis-a-vis the LLC, they'd get what's called a charging order. They step into your shoes for your economic benefits and burdens for your LLC. So if that LLC distributes rent money to you, your creditor can step in and snag it. But if that LLC just holds on to that rent money, generally speaking, your creditor cannot go in and get it. They can't manage the LLC, so they can't direct the land trust. They can't direct the sale of the property. They're just sitting there with their hands out like Oliver Twist. Please, may I have some more? And if you decide not to distribute any money, your creditor's doesn't get anything. More importantly, that charging order gives them your economic burdens as well. So if your LLC makes a capital call and says, hey, we need every member of the LLC to pony up 10 grand, guess what? Your creditor has to pony up 10 grand. Not only that, if the LLC makes money, whether they distribute it or not, it goes to your personal income tax returns. Now your creditor is going to be subject to those income taxes. So it's a great deterrent, that LLC charging order, if your state has it, which most states do. So don't name yourself as the individual beneficiary as a land trust. The land trust, name an LLC. Contracts, please use written documents. Read the terms. Don't trust somebody's verbal summary of your deal. Read every word. It can save you in the end. And asset protection, plan early. Plan early. Once you already have a potential lawsuit, you cannot then go do asset protection. It will be a fraudulent conveyance and it will get undone. And I think I'm out of time. Am I out of time, Jim? Okay. Vacation rentals, please, if you're going to do a vacation rental, know the laws. Pay any applicable sales and occupancy taxes. The penalty in Asheville, if you do a vacation rental outside of where it's allowed, is $500 a night. For every night that somebody stays. So that's $3,500 a week. Don't do it. Make sure you have the right insurance. So if you have a beautiful house and all of a sudden you decide to turn it into an Airbnb, your insurance won't cover it if somebody slips and falls. You need to get insurance that is specifically for vacation rentals. If you have events at your house, weddings, whatever, you need to make sure your insurance policy covers those events. Otherwise, you could have a problem and not be covered at all. Or like for me, I had a water leak that not only had a $25,000 problem with the wood floor I had to replace, but I lost guests during that period of time. My insurance company not only paid for the floor, but paid for my lost revenue because it was a vacation rental policy. If it had been just a regular landlord's policy, I probably wouldn't have gotten the floor fixed or gotten the lost revenue because I didn't have the right policy. If you have a rental property and it goes vacant for more than a certain number of days, and it's usually between 30 and 90 depending on your policy, tell your insurance agent, because they're going to have to change it to a vacant house policy. Or somebody steals your HVAC, which happened to me on a house in between tenants, your insurance company won't cover it. That would have been $8,000 out of my pocket. But luckily, they got stolen in such a quick period of time that my 30 days or 90 days hadn't run out. But boy, you better now, I'm like, anytime a property goes vacant, I'm calling my insurance agent, switch it to a vacant rental property unless I know I can get another tenant in there right away. Because, insurance, no offense to insurance agents in the room, they will try to find the ways to get out of paying you, right? All right, I could go on for 3 days about this stuff, to be honest with you. But that's it for time, I think, and so I'll be happy to answer any questions later. And thank you for listening to the boring, scary stuff.
not boring. It was a little, you can leave that on, because we're
Oh.
gonna do some questions.
Oh,
It wasn't boring, would you guys agree? I mean, it came like a fire hose with lightning lips, but it was at points scary. Would you guys agree?
Yep.
I mean, it was for me. Some of the things you talked about. I mean, I was whispering to my daughter Melissa, like, what to do if we both die, and and it included call Mary, please.
well,
You'd
and
help my kids, wouldn't you?
of course I would. And that is something, everybody should have someone, particularly if you have a spouse or children who are not in the business and wouldn't know what to do, pick a real estate investor, financial friend, and make sure they know enough about your situation that they can advise your loved ones and help them through it, because they won't, if your loved ones are not involved, they won't have a clue what to do.
We all help each other. That's the value of a network. You guys are going to see Walter Walford. He's helped a lot of people that have died and lost assets, left assets behind, hasn't he?
Yeah.
And we help each other. I've had the extreme pleasure of helping Mary a few times on things, and I've been honored that she's been able to help me on some things as well. That really is why we began when she came up, saying how valuable your network is, and having people you can call along the way. You guys want to do a few minutes of Q&A? Michael Zuber, come on up too. I don't know where he went. There he is.
By the way, if I say to my kids one more time, remember, boys, your network is your net worth, they go, oh, they're so tired of hearing it.
We've been passing out forms. We don't have enough, but
Oh, I have more.
Mary's-
These, if anybody
Yes,
wants one, I
okay.
have more.
We're going to have some in the back. You've got 2 different consulting gigs, right?
Yeah, so what I mentioned earlier is I'm transitioning from active lawyering to consulting, so it's bigger and more limited at the same time. So I'm not going to say I'm giving legal advice, so you can't rely on me for legal advice, but all the same knowledge is still in my head. And so what I want to do is, well, let me back up. I have found that there's a need for people to help real estate investors understand all this stuff that I've been talking about, because even if you go to the lawyer, you don't understand what they give you. They don't spend enough time to dig deep into the issues and ask the right questions. And so I've put together several packages to do 6 to 8 hours of consulting and then 2 hours of follow-up, work with your lawyer if necessary to get into any issue almost you want to get into, because I have a lot of
What are you doing
experience.
for young people?
So the young people thing is, I'm hopefully in March, maybe April, depending on my time, going to start a twice a month Zoom video conference call for really anybody. I wanted to do it for college students, but I've had so many people in their 30s tell me they want to do it. And it's going to be financial literacy, lifestyle hacks, wellness, it's whatever, and I'm going to bring in speakers. But essentially, for these young people who don't understand financial literacy, I want to talk to them about everything from mindset, goal setting, knowledge of all the different ways you can be employed, a business owner, that model right there. All the different ways you can make money, how do you save your money, how do you do it tax-free, how do you protect it from creditors, and when you're old, how do you pass it on?
Do you have a price?
Yes, so for college, anybody who's a full-time student, $25 a month.
Wow.
And the reason I'm doing it, that's cheap, but people, it's not free. I would do it for free, but people value what they pay for.
So why?
And what I've found out is that people who want it for free won't take it seriously, and they won't do the work to move themselves forward. So full-time students, $25 a month. I'm thinking if you're not a student, but you're 30 or under, it's $50 a month. And if you're over 30, I don't know, $100 a month or something like
How many
that.
of you guys know somebody in your family or friends that would take that?
Yeah. So the plan is to
Melissa,
do,
Rick,
twice a month video conferencing calls, and if they can't make that call, it'll all be recorded so they can go back and look at the library. And then hopefully we'll get to 2 times a year getting together for 2 or 3 days, and it will morph into a little bit of a mastermind for these young people. They can help each other and
I'll come on as a guest.
bring in guests and all that. So that's my calling. That's what I really want to do. But
It's a strong why. All right, let's move into Q&A. I love that. Michael, come on over. Let's talk a little bit about rentals, and we can talk about prohibited transactions. We can talk about estate planning, LLC structures, 1-member, 2-member, whatever you guys have on those 2 topics. Kevin?
Mary,
yes.
you talked about traditional IRAs and making sure that the beneficiaries are done the right way so that it won't all come out taxable.
Yes.
Never heard that before.
Okay.
Can you elaborate?
So the question was getting your beneficiaries right so that it doesn't all come out taxable on a traditional IRA.
Yes. So on a traditional IRA, obviously when your beneficiaries get the money, they have to pay the income taxes because you never did. If you name just straight individuals, then we can use their life expectancy, so that's easy. But let's say you have a minor beneficiary and you want it to leave it in trust so that somebody can manage it for them till they're 35 or whatever. There are certain rules we have to meet that will allow us to look through the trust to use the life expectancy of the trust beneficiary to stretch out those payments. If we don't meet those rules, then the entire lump sum has to be paid out, usually in a year, sometimes 5 years, usually in a year. So we've just greatly accelerated that income. And not only that, but if it goes into an irrevocable trust, if that trust is not set up correctly, we're at trust income tax rates, which the maximum bracket is at about $12,000 or $13,000 worth of income. And then they're in the top income tax bracket in the country, right? So we want to make sure that that trust is set up properly so that we can use the life expectancy of the beneficiaries, and it's kind of a conduit. Same thing if you have a trust for a spouse, we have to meet certain rules to qualify for the marital deduction and, you know, all that. Also, if you name, let's say you've named individuals and a charity, because a retirement plan is a great asset to leave a charity because charities don't have to pay income taxes, right? So a lot of times people want to leave their kids and maybe 10% to a charity. The problem is on a certain date after death, we call that the beneficiary finalization date, the IRS takes a snapshot of who those beneficiaries are at that time. And if any one of the beneficiaries is not either an individual or one of these qualifying trusts, so that charity is not a designated beneficiary, term of art, then it kicks us back into that all dumped out lump sum, right? Because we have a 10% charitable beneficiary. So we need to either advise people to say, set up 2 IRAs, name the charity as the beneficiary of this one and your kids as the beneficiary of that one, or we have to make sure that that charity gets its distribution before that snapshot date. See what I mean? So there's so many ways that people, they just don't know what they don't know. So they're trying to do the right thing, they're setting up a trust, they're naming a charity, and they've just, excuse my language, screwed their beneficiary for income taxes. Completely.
That help, Kevin?
Yeah.
Okay, next question. Tom?
I thought you mentioned both irrevocable trust and revocable trust.
I did, in different contexts.
Irrevocable and revocable,
Can you
and
explain the difference in why you would want to use one versus
Yeah.
the other?
the difference between a revocable trust and an irrevocable trust. That's a very good question.
Yeah, so that's an easy answer, I'll tell you that one. Revocable means you can revoke it.
Get that.
Irrevocable, you can't revoke it or change it. That's pretty easy. The harder part is why you would use one or the other. There are so many different types of trusts for different purposes that is a full day seminar on fully answering that question. I'll give you some examples though. A revocable trust is usually used either to avoid probate, provide management, having someone else help manage the assets if you become disabled or something else. It's usually used more during lifetime. The assets are still controlled by you. They're still counted in your list of assets when you die for your estate. They're ignored for income tax purposes. It's just under your Social Security number, you know, blah, blah, blah. Whereas an irrevocable trust is usually used either because someone has died and their revocable trust has become irrevocable, meaning it's no longer changeable because the person who set it up is dead, so they can't change it, and they don't want it changed. Or if you set up an irrevocable trust during life, it is for many reasons, but one of them might be, I want to get this asset out of my list of assets for my estate planning, and I want to go ahead and transfer it over to my beneficiaries. So, but they're young. Your kids are young. I don't want them to run off to the Swiss Alps when they're 18. So I might take this chunk of money, gift it into this trust, and again, we have basis issues, so we have to be careful, but gift it into this trust. It's irrevocable now. I can't change it. It is what it is, but now that asset, let's say it's $100,000 cash, no longer in my list of assets when I die, so I won't pay estate taxes on it, for instance. Another reason we use an irrevocable trust a lot is life insurance. So if you had a $3 million policy of life insurance, that death benefit, even if it's a term policy, is listed in your list of assets to see whether you have a taxable estate when you die. So you've got all your other assets you've built up, plus $3 million. Oops. What if you're in a 40% estate tax bracket? Now we just lost 40% of that $3 million policy to the IRS. So what we might want to do is take that policy and put it in an irrevocable trust When you die, you no longer own it. And there's some rules around that, but you no longer own it, so now the full $3 million goes to your kids. There's a lot of reasons.
Is that on a stepped-up basis when it goes over?
Well,
Is there
life
stepped-up
insurance doesn't have a
basis?
basis.
Some of the one before it, when you're talking about transferring
No.
an asset.
So if I transfer an asset during my lifetime, it will carry over whatever my basis is in that property. So we're always looking, all right, well, I've got a basis that's an income tax issue. I need to get this asset out of my name for an estate tax issue. Which is more important? Estate tax rates are higher than income taxes, but do I have a taxable estate? Well, I need to get this out of my estate. Am I trying to qualify for something else?
If you waited, it would be stepped-up basis when.
Right. If you waited, it would be a stepped-up basis when you died. But part of why I want to be this consultant is, everybody in this room knows where they are now. They may know where they want to be. In between is the giant rat maze, and you don't know whether to turn right or left or go straight. My job is the eye in the sky that knows where you are, knows where you're going. You can say, turn right, turn left, go straight. So this question, like, do I set up an irrevocable trust or not? Well, we've got to look at everything. Are we trying to avoid state taxes, estate taxes? What's the income tax ramification? Are we setting this up so a disabled child can qualify for Medicaid? Why are we doing it? Is it for charity and we want a charitable tax deduction? I mean, that's what I do.
Can you see why having Mary in your corner would be valuable? Rich, Lennon. I'm sorry, and then we'll get
Much as
Kuquan.
fun to talking tax strategies, I got a question for Mike.
Okay, good. Remember what, if you spell out the IRS, what does it stay? Theirs. So I'm just saying. And Martine and some of you really young wholesalers, I mean, you're thinking I'm never going to die, but the other place you guys pull into this is going to be when you're doing title searches and you're dealing with motivated sellers that think they own something that they don't even own. So grasp of what you can. Go ahead, Mike.
Well, he's got to ask a question
I haven't
first.
heard the question yet. Let me guess what it is.
Karnak says, no,
All right, so
for those of you old enough to remember
like a lot of
Karnak.
investors, I've considered raising a friends and family fund.
Sure.
So I was curious on your structure of that. So I noticed you're borrowing $2 million, you're paying out 6% cash flow, and then you give them 20% of the equity. So two questions for you.
Sure.
So the first one is, you said, hey, I think my investors are getting great returns. What do you think over the 20 homes that you flip, you think their return is?
Yep.
That's the first question.
Sure.
And the other one is, they go bad sometimes, right? So how do you manage the situation where, hey, you lost some money, obviously you're gonna still pay your 6, you're gonna make them whole.
Yep.
But like, do you give them a kicker? Like, what do you do kind of with that?
So good questions. Everybody hear the question? Excellent. So I'm very much into actuals, right? I'm actually an accountant trained in school, so we'll talk about actuals. I've done annualized returns on all the deals, the 10 deals that completed already that I referenced in my slide. All of them annualized were north of 20%. Right? So they were, the holds were 4 to 6 months. So again, just so I don't confuse you with vocabulary, annualized means I'm taking that return over a 12-month period. So their annualized return is over 20%. I would say that's pretty good. Right? They've been as high as over 30, but
Take
no
that.
return has been less than 22%. Question 1. Question 2. Yes, deals, raising private money, they can go bad. I have not had one go bad because I am so risk averse. When I raise private money, as I said in my example, I only ask my private investors to bring in the purchase price. So what does that mean? What goes unsaid? That means I'm putting in my own personal capital for the repairs. In the example that I talked about, it was $40,000. That is 100% my capital, is not borrowed money. So the money at risk is mine first. So in essence, in my example, that house that I sold for $169, I mean, it would have to sell for 50% less for my investor to be hurt, right? So I'd have to lose profit, which in that case was almost $40,000. I would have to lose my personal capital, which is $40,000, before the investor is at risk. And frankly, I'm a landlord. I'd have bought him out and kept the damn property.
Good answer.
Seriously, I mean, I rented for $12.50. You do the math,
Right.
right? So my investors in the programs that I do in a kinder, they're literally friends and family, right? These are people I've known an average of 20 years. I'm not losing their money. I won't do a skinny deal.
Good attitude.
Yeah.
Are there any SEC requirements when you're raising that kind of money?
There are lots of SEC requirements when you're raising private money. If you stay with, I'm not a lawyer. I'm a guy who talks to friends and family.
I'm a
about getting
recovering
money.
lawyer.
Yeah.
I don't want to be a lawyer.
So yeah, you can't market, you can't do all these things, and I'm not marketing. I'm not asking. I don't want. I I'm just sharing what may work for you as you're raising.
Can I add to that?
Yes,
The
please.
quick answer
Bail me
is
out.
that there are federal laws, and there are state laws that tell you when you have to register a security and what the exemptions are. So you're probably under sort of friends and family where you're not going out with soliciting materials, you're not soliciting to strangers, yada, yada, yada. So you need to find a SEC lawyer to look at the federal and state laws to decide what you can do without registering or filing for an exemption. We've got several questions back
And
here.
an example of that would be like Carolina Hard Money, Wendy is right over here. She has a registered fund.
Yeah.
And I would advise talking to her about how she created the fund and what type of offering she created, if you want more information on it.
Yeah, the last thing I'll say on that question that wasn't asked, but I'll share it, is I don't commingle. Again, I'm a simple person. Like some people go
No
out and go, hey, I
commingle.
need to raise $200,000
Right.
and I get 5 people. That's freaking too hard for me, right? I'm one asset, one person, because again, it's my uncle. it's
Secured
my
against
mom,
the
it's my-
asset
yeah.
every time.
Recorded
Same,
note,
I'm the
recorded
same. Jason?
Mayor,
Oh.
Sorry. Fuquan, go ahead.
Yeah.
I'm sorry, I forgot you. Go
He's
ahead.
been-
Protection. So a lot of people here are buying rental properties, buy and hold, or rehab to rent. The gentleman said over there. How are you setting this up? Are you setting up a series LLC, or are you having each property in separate LLCs? What is your recommendation on how to set up for asset protection?
Good question. Did everybody hear that, or I need to repeat the question? So, what do you set up for asset protection if you're buying multiple properties? I'm going to tell you the classic lawyer answer, which is it depends. And it depends a lot on somebody's risk aversion, risk tolerance, the money they have to put into filing fees and annual fees, what state they live in. It's a lot of things. So for me, for instance, I have a number of LLCs, and a lot of them have one property per LLC. And the reason that I did that for the majority of my properties is because some properties I maybe had my brother and sister were part owners with me, and this other property was just myself. I wanted different owners. Or one property they were paid free and clear, so maybe I had $800,000 equity in one property. I didn't want to put another property in it and potentially taint that property if somebody slipped and fell in property one. So here's what I've seen, and again, I think it's very dependent on the person and the situation, which is why I don't ever do a cookie cutter anything like some lawyers do. I want to sit down with that person and find out all the facts and what makes sense for them. So I have some clients who over the years have said, look, I'm going to set up one LLC, I'll put all my properties in it until I've got X dollars of equity, 500,000, 100,000, whatever their tolerance was. And once I have that much equity, then every new purchase will be in LLC number 2 until I build up that equity, and so on and so on. How much were they willing to put at risk for any one property? Other people have said, I don't care how many filing fees there are, I only want one property per LLC. Other people have said, I'm not doing any properties in LLCs, I'm doing everything in a land trust because I want the anonymity and I don't care about the LLC piece. Or I'll have the LLC as my beneficiary. So there's no one black or white answer. When I started doing in LLCs, I wasn't really even thinking about land trust at the time. If I bought a new property now, depending on the circumstances, I may put it in a land trust with my LLC as a beneficiary, or more likely, I would do land trust with a personal property trust as a beneficiary, and then an LLC, and then my revocable living trust. I'd make it as hard as possible for people to figure out what's going on, because lawyers are stupid and look for low-hanging fruit. They don't want to work that hard to come after your asset.
Kevin, that was your exact question a couple days ago on Facebook.
Yeah.
Did you follow that? So she said land trust,
So yeah, so
personal
let's take
property
that.
trust.
I always go up. Some
LLC.
people go up or down, but I start with the house at the bottom of my piece of paper. Who owns the house? It is deeded into a land trust. Okay? That land trust has a beneficiary that's maybe a personal property trust. I'll explain why in a minute.
That's one extra step.
One extra step that most people don't do. And then the beneficiary of the personal property trust is my LLC. And the owner of my LLC is my revocable trust. Why did I do all that?
That's 5 layers.
Why did I do all that? So the land trust, the thing I like about the land trust, a couple things. One, they're easy as heck to set up. You pay for a template once, or you get a good trust once. You can repeat it on your computer for 100 properties. Just change the name of the trust, change the legal description, maybe change your trustee, spit out a new trust document. There's no filing fees, there's no annual fees with the state. So they're easy to set up. Number 2, they're very anonymous. So if I'm in a state where I don't have to put the name of the trustee on the deed, and I can just say the ABC Land Trust, and so the property is deeded to the ABC Land Trust. Nobody knows who that ABC Land Trust is associated with. There's nothing filed at the Secretary of State that says who owns the ABC Land Trust, right? So it's anonymous. It's a great smokescreen, and people don't understand it. And the trust document itself prohibits the trustee from disclosing any information about the trust terms, who started the trust, who the beneficiaries of the trust is. And we know, a common friend who was a trustee on a land trust, the land trust got sued. The opposing attorney tried to force the trustee, our mutual friend Steve, to disclose the beneficiary of the trust. And the judge started to make him do that. And Steve said, well, Your Honor, you better indemnify me for breaching my fiduciary duty and going against the terms of this trust, because I could get sued for millions of dollars. And the judge said, never mind, we don't need to know.
Powerful.
So nobody knew who the beneficiary was. Nobody knows whose deep pocket is out there. So the land trust is great anonymity. So house in the land trust.
Privacy.
Why would I potentially have a personal property trust as the next beneficiary? First of all, I use the exact same trust document, whether it's owning land or personal property like notes. Some people use separate. I use the same thing. Same idea. Anonymity. Nobody can say who the beneficiary is. Anyway, personal property trust. If somebody breaks through my land trust and gets the judge to say who's the beneficiary, what do they find? Another anonymous trust. Now they got to get the judge to break through that trust and say, well, who's the beneficiary of that trust? It's an LLC. Great, well, there's my brick wall creditor protection, right? So, and not only that, in some states, when you deed a property to a trust, you're required to name the trustee in the deed. So anybody can find the name of the trustee. Or, the beneficiary, not the trustee. The beneficiary. In some states, that's required. Well, great. So if my personal property trust is the beneficiary, that's what's listed in my deed. It still doesn't give them any information. They don't know who my personal property trust is related to.
Privacy.
Yeah.
Paul?
So one of the things I find out if you're going to refinance, and you can't, like some of these loans, you got to have your name in them.
Yeah.
So if your name's floating out there, then you put them
Depends
all.
on your type of financing.
Depends on your financing.
Right, so if it's-
So one plug for working with private
Commercial-
lenders,
Yeah,
by the
but
way.
I've also had commercial banks lend to my land trust.
Yeah, what I've found is if you had a good relationship with your bank, usually more regional banks, and you give them full transparency about what you're doing, and they realize that neither the land trust nor the personal property trust are creditor protected, and they can come get you, then they're more sometimes willing to do it.